Good afternoon, I'm Bob Friedman. Thank you for joining us today. We have PowerPoints on both screens, plus there's copies in your folders. Everyone have a folder? Everyone needs a folder, raise your hand. I just have a few warnings before we get started. First, this is not a substitute for legal, investment, or tax advice. You need to consult with your own advisors to see what's best in your particular situation. Because just because Mary across the street was able to preserve her home, it might be a different situation than you're in. The purpose today is to motivate you to plan, to dispel myths, and make sure your wishes are carried out, and know what questions to ask when you do talk to your advisors. Also, in the interest of time, I'm going to ask that you hold your questions till the end. We'll be glad to answer your questions then. Also, if you would like a free Medicaid planning consultation, just write that on the top of the comment form. I'd appreciate it if you could fill out the comment forms and leave those at the beginning. If you'd like a free consultation, we will call you if you write it on the top that you'd like a free consultation. How many people here want to go to a nursing home? I usually get that response. No one plans on it. People say, I will never send my mother or father to a nursing home, but sometimes you have no choice. It can be very stressful mentally and physically to take care of an older relative. It may be impossible. Or very often people break a hip, they go into rehab, and they never make it home. They go into long-term care from there. So we have to plan for that, even though, especially in these days, past 14 months, with not being able to visit your loved ones, I know there's more and more of a trend to keep people out of nursing homes as much as possible. But sometimes it's inevitable. We don't have control over that. So what this is all about is paying for nursing home care. And how do you pay for nursing home care if you do end up in long-term care or assisted living or assistance at home? The source of payment for that might be your fixed income or your pension, your investment income. You may have to get a reverse mortgage. There's also long-term care insurance. Medicare, not Medicaid, will cover part of your rehab stay, 20 days in full and copay after 80 days. VA pension, there's aid in attendance if you or your spouse served in a war for at least 90 days. VA has additional benefits called aid in attendance. I can give you references about who can help you with those applications. And the last resort, and this is based on being impoverished, is Medicaid. That's the whole point. You have to understand that you have to be impoverished to qualify for Medicaid, for long-term care, or some assisted living facilities take Medicaid. There's about a dozen of those in Erie and Niagara County. There's lists of assisted living that also take Medicaid as payment. Some don't take any Medicaid at all. So that's the last resort. So we're talking about, I have a tremendous amount of material to cover, so we'll try to get through this as easily as possible. So the system, Medicaid, and it's very confusing, and it's bizarre, and it's complex. New York State's a little bit more liberal than other states. In some states, if you have too much income, you're automatically disqualified for Medicaid. To qualify for Medicaid, you don't have to have any residency here. You can move up from Georgia today and qualify for New York Medicaid tomorrow. So there's qualifications. You have to be impoverished. There's for community or home Medicaid, it's income of, you can keep $884 per month if you're single. If you're in a nursing home, you can only keep $50 per month. Resources, you can only have $15,900 in resources, and there's all sorts of exceptions to exceptions, which is why you need to talk to your own advisors that have all your information in front of them to say how you would qualify for Medicaid. Many of us have heard about the look back, that's the 5 years. There's a lot of misinformation about that. Currently, so when you apply for long-term skilled nursing home care, you have to provide records for the past 5 years. And they will ask you to explain withdrawals of usually about $1,000. It could be other withdrawals, but they will ask you an explanation. They're going to ask you all your bank records for the past 5 years. Currently, there is no look back for assisted living. It was supposed to go into effect earlier this year. There's going to be a look back penalty for assisted living and community care. So you can get Medicaid for in-home care. There's some disadvantages to that. You would have to use an agency for aides for that, and there is sometimes you're better off using private aides than agency aides. So basically how this look back, you hear about the 5-year look back, it used to be 3 years, now it's 5 years in which you could be penalized for making transfers within the past 5 years. So what they change these figures every year, but for Western New York has a different rate than Rochester and Central New York and so forth. But anyway, for Western New York, for every $11,000 that you've given away over the past 5 years, you'll be disqualified from receiving Medicaid for 1 month. So if you gave $110,000 total over the past 5 years, you would be penalized for 10 months. You'd have to private pay for 10 months if you've made gifts. We'll talk more about what the gifts are, what are gifts and what are not gifts. But that's what the effect is of the 5-year look-back period. So if you transfer assets for the purpose of qualifying for Medicaid, it's considered to be a gift which will be penalized for. Now you can challenge this, okay? There's a presumption if you made gifts in the past 5 years, but what we're recommending, if you get regular medical checkups to see you're healthy when you're making these gifts, gifts usually of under $1,000, you can challenge that at a fair hearing that you're saying, I did not make these gifts to qualify for Medicaid, even though it was only 3 years ago, because I was in good health then. So you're entitled to a fair hearing before Erie County. So there's one confusion is when people say, I can give away $15,000 a year, right? You probably heard that. You can give away $15,000 per year. That $15,000 is the estate, the U.S. Gift and estate tax exemption. You can give away $15,000 to as many people as you want every year, or $30,000 if you want, to as many people as you want. You don't have to file a gift tax return, and that's what the $15,000 is. It has nothing to do with Medicaid. So that, even though you're allowed to give that under the estate and the estate tax laws, it still would disqualify you if you make a gift of $15,000 or more. So New York used to have a gift tax. New York no longer has a gift tax. Believe it or not, New York actually eliminated a gift tax quite a while ago. But there is this federal gift tax. If you were to make a gift in excess of $15,000, you'd have to file a gift tax, but there would be no gift tax return, but there would be no gift tax. You're entitled to make these gifts in addition to your $11 million lifetime exemption. So it doesn't mean that much anymore, but when the estate tax limits were lower, it meant more, where people could give away make gifts annually in addition to what their lifetime exemption was. They'll also look at what past pattern, if you usually make gifts for birthdays and graduations and so forth. If that's your usual pattern of gifting, it may not. You can say it wasn't done for the purpose of qualifying for Medicaid. There are protections for you if your spouse is in the nursing home and you're still at home. You have protections where they allow you to have enough resources to live on. And first of all, if you can have at least $74,000 in assets. This is in addition to your house and your IRAs and everything else. If you have a spouse, that's in the husband or wife in a nursing home, you're allowed to keep at least $74,000, and your combined income of $3,259. In addition to that, if you have $1 million and your spouse is in a nursing home, you can still refuse to support your spouse. You can sign a spousal refusal, and your husband or wife will still qualify for Medicaid as long as they will still qualify for Medicaid, regardless of how much money you have if you refuse to support your spouse. However, the county attorney can sue you in family court to recover the nursing home costs, but that would be at the Medicaid rate. So right now, nursing homes are about $500 per day, and the Medicaid reimbursement, I think it's around $175. So you would be sued for the Medicaid rate. It depends what county you're in, but sometimes the county attorney will sue the spouse that's refusing to support their husband or wife. So that's just some options available to spouses. Another thing you may want to do is, if your husband or wife is in a nursing home, you may want to update your will to remove your spouse as a beneficiary in your will. Because that may happen. If you're at home and your husband or wife is in a nursing home, you possibly could pass away before them, and you don't want everything going to them, because then all your money will not go to your children eventually, but it will go to the nursing home and it'll go back to the Erie County for Medicaid. So you should talk to an attorney about updating your will, but the county can still, even if you disinherit your spouse, the county can still file what's called a right of election against your estate. That would be, the county would have to initiate that, file a right of election for half of your estate. If you're in a nursing home, the county would file a right of election against your spouse's estate to get the one half so that they can recoup it. But for the most part, you should disinherit your spouse, and you can disinherit your spouse. They have what's called a right of election against your estate. One thing you need to understand too is that you can disinherit your children. They're not entitled to anything. Some of them think they are, but that's just something to keep in mind. And this is something I have the will information sheets in the packet. We have clients fill out a 2-page intake form so we can advise them on non-probate versus probate assets. And this is something we get questions about every day, but people don't understand. And there's many people that die and their estate does not have to go through probate, does not pass through the will, because there's many assets that do not have to pass through your will or for probate, and there's pros and cons to that, okay? I give a seminar just on that topic, on avoiding probate. And there again, you have to talk to your advisors. There's pros and cons to avoiding probate. But anyway, these non-probate assets, when someone passes away and had been in a nursing home, the county will file a lien against their estate to recoup Medicaid, but it can only be against their probate estate. Any non-probate assets, which we'll talk about, they can't levy against those non-probate assets to recover for Medicaid. For 11 months, about 12 years ago, New York State permitted recovery against non-probate assets, which does not make any sense. But anyway, they did that. That law only lasted for about 11 months in New York State. It's not in effect any longer. For instance, life estate. So non-probate assets are, for instance, like life insurance. As long as you have beneficiaries, they will go directly to the beneficiaries. We do have instances where people never updated their beneficiaries and all the beneficiaries are deceased. Then your insurance policy proceeds will be payable to your estate. So you may not want that. So, someone made their mother their beneficiary 50 years ago and their mother died and they never updated the beneficiary designations. IRAs, those are non-probate. Those go directly to your beneficiaries. Annuities, if you have death benefits in your annuities. We could spend about half an hour talking about bank accounts. So your bank accounts can be non-probate, either joint, which has its pros and cons. You can have it payable on death, your bank accounts, or you could have it Mary in trust for her daughter, Sarah. those types of bank accounts. But there again, you need to get advice on whether or not you should put your kids as joint owners on your bank accounts. That can cause problems. And as an alternative to that, you may want to have them access to your bank account with a power of attorney, which we'll talk about shortly. One automobile can be transferred to the DMV without a court certificate. You can, if one motor vehicle up to $25,000, by completing an affidavit with a DMV, you can have a vehicle of a deceased owner transferred. We'll talk about living trusts, transfer on death. I think it's been about 20 years or so. You can, so far, you can have your investment accounts transfer on death. So upon your death, it goes to your beneficiaries, your stocks and mutual funds. You can have those transferred on death. There again, you need to look at the pros and cons of doing that and whether, which we'll talk about in your investment accounts. So if you get one thing out of this seminar, and that is number 4, power of attorney. That's the most valuable tool you can have for what they call emergency Medicaid planning. If you've never done, we'll talk about this at the end too, if you've never done any Medicaid planning, asset preservation, you can do that if you have the proper power of attorney. Very inexpensive document. It could avoid the need for guardianships, Article 81 guardianships. So power of attorney, there was major changes in 2009 to the power of attorney form. As far as adding a gift writer, next week, June 13th, there's an entire new form. Well, it's not entirely new, but there's a new form that can only be used for people that sign beginning on June 13th or later. So your current powers of attorney are still valid. You should probably still have an attorney look at it, see whether it's good for your asset preservation. But June 13th is going to be, it's a more simplified power of attorney. It's one document instead of 2. There's also new laws that are going to penalize banks for not accepting powers of attorney because they've been giving people runarounds. So there's penalties and a whole procedure on banks being able to accept powers of attorney. So powers of attorney, and this one question we get every day is that, is the power of attorney still valid when the person dies? No, your power of attorney is valid only during your lifetime or unless it's revoked. You can revoke it, or sometimes through an Article 81 guardianship it can be revoked. And we've done that we've gone to court to have powers of attorney revoked where someone was abusing the power of attorney. It's usually a child that's abusing the power of attorney. She was stealing from her mother, using her mother's credit card. So they can be either immediate, when the day you sign them and your agent signed it. Now, as of 2009, agents also have to sign the power of attorney and accept their responsibilities. So powers of attorney could go into effect immediately when you and your agent sign it, or it can be springing, which probably only about 1% of our clients use that. It'll go into effect at a future event, usually a doctor certifying that you're incapacitated. So some people are not very trusting at all of their agents, which they probably shouldn't appoint them to begin with. But if you don't want your power of attorney to be go into effect until you become incapacitated, you can make it a springing power of attorney, which would go into effect when it's attached to a certification from a doctor that you're incapacitated. So guardianships, like I said, they used to revoke powers of attorney. They can also may be necessary if you've never signed a power of attorney. And a few times we've gone to have guardians appointed simply because someone because they had a power of attorney, but they didn't have the gift writer. The gift writer authorizes gifts in excess of $500 per year. The new power of attorney will authorize gifts to up to $5,000 per year, but you can modify it to authorize gifts in excess of $5,000. So we're doing that in the new powers of attorney. We recommend that in the modifications, that you authorize your agent to make gifts in excess of $5,000 for this emergency Medicaid planning we'll talk about at the very end. So sometimes we've had when someone had a power of attorney without a gift writer or had no power of attorney at all, we've had to go to court to have a guardian appointed to do this emergency Medicaid planning. So there's additional cost, far greater cost than getting a power of attorney, and it can be delay, and it could be having to private pay nursing home until you're appointed as a guardian. So guardianships, Article 81s, are for alleged incapacitated people. It's a rather low threshold. You don't have to provide medical proof to have someone appointed as a guardian. It can be from testimony. Someone needs assistance with making decisions about their finances and or their personal care. So that's what's called, used to be called conservatorship. Have a guardian appointed for someone that needs assistance or direction. And as I said, there's a new law that goes into effect for powers of attorney on the 13th. One overriding consideration is that nursing homes are not really allowed to discriminate against Medicaid patients, but they do, okay? So if you don't have substantial assets and or like 100,000 or so, and or if you've made gifts in the past 5 years, when they see that on your nursing home application, they're going to say no beds are available. So you're going to be limited. You may end up down in Gowanda. You're going to be limited, or I can rattle off a lot of really bad nursing homes around here. Even the 5-star ones aren't that great. That you may end up in not a very good nursing home. So that's what you have to keep in mind. That's why I say you need to talk to your advisor. What are your goals? Provide for your kids or your grandkids, or making sure that you get proper care if you do unexpectedly have to go into a nursing home. For most of our clients, their most valuable asset is their home, and there's quite a few protections where you can protect your home for your family. First is transferring your home to your children with a life estate deed, and there's another alternative to that is transferring that into a trust. We'll talk about that in a moment. But you prepare a new deed and transfer your house to your children. You keep life use, which means you have a right to live there the rest of your life. They can't kick you out. You're still responsible for the property taxes. You still get your property tax exemptions, your senior and veterans tax exemptions, as long as you're still living there. That's a non-probate asset. That's an example of a non-probate asset. Upon your death, the house will automatically go to your children. And there'd be no Medicaid recovery. If you qualify, if it's been 5 years, it's been more than 5 years since you transferred your home with a life estate deed to your kids, it's not going to be considered as part of your resources. There are some disadvantages to this, which can be eliminated by transferring it instead of directly to your children, transferring it to an irrevocable trust. And we'll talk about that, a living trust, what it's called. So some of the disadvantages are, if you decide that you want to sell your home and you're sick of the winters and you want to move to Florida, then you're going to have to start all over again with a 5-year look-back period. So if it's in a living trust, you don't have to start all over again with it, because the trust would sell your home for you and buy you another house. The other disadvantage is if any of your kids go bankrupt, and I've seen it happen, they don't have, so with real estate, there's 2 levels of ownership. There's life estate, which you have, and then your children have a remainder interest, which they don't have a right to occupy the property until you pass away, but still the property is still exposed. If they go bankrupt, it could be a substantial amount, probably most of your value of your house would have to be paid to the bankruptcy court if they go bankrupt. So some people transfer the house to the child least likely to go bankrupt, and that they sign an agreement to share the proceeds with the other children or their siblings when they pass away, when you pass away. Or if your children are sued, there could be liens against their house. And I've also seen the signs that children die before their parents do. And possibly their interest would have to, an estate would have to be open for them to transfer their interest. So it's very complicated. All these complications can be eliminated if you transfer it to a living trust. And that's what most people are doing these days, is using a living trust instead of, so that the house is in the name of their children as trustees, not in their individual name. And I said there's no Medicaid recovery, no probate. Another method, 6B, which is not very often used, but it's available, the numbers have to work out, is that you sell your house and then you purchase another house with your kids, or you give your kids money to add an in-law apartment or something like that. As long as you're there for 1 year, then that's it's no longer considered your resource. The numbers don't always work out that well with that. It's not done too often, but it is an alternative. So your primary residence, you have a $906,000 equity exemption in your home, taking the value of your home, less your mortgages is your equity. So, and that's available to the nursing home applicant. For the first 6 months, they would exclude the value of your home in qualifying for Medicaid. But once you're on Medicaid for at least 6 months, there's a presumption you do not intend on returning home, so your house would no longer be exempt, so would need to be protected. One thing you need to keep in mind, there's no penalty as far as transferring assets among spouses, husband and wife. There's no penalty, no look back. You can transfer as much as you want to your spouse, and there's limitations on how much your spouse can have. So there again, you need a power of attorney. Many people are in misapprehension, husband and wife are on the deed, but if your spouse ends up in a nursing home, you're going to want to get the ownership out of their name. And if they can't sign a deed, either physically or mentally, they don't have the capability to sign the deed, it's going to have to be a guardian or power of attorney that signs that deed. You cannot sign the deed for them. There again is why you need a power of attorney. You can also transfer unlimited, actually, assets, including your home, to minor, disabled, or blind children. Could be set up in a trust for them. There's also an exemption if you have a brother or sister that's been living with you for the past year, and they say have an equity interest, they've been helping with expenses, and you end up in a nursing home. You can transfer your house to your brother or sister that's been residing with you for a year, and there's no penalty for that. There's another exemption. Another exemption is a caregiver child that's been residing with you for the past 2 years. Usually the child's been living there for the past 50 years, but as long as they've been living there for at least 2 years and they've been caring for you 2 years before you go into a nursing home, you can transfer the house to them, and again, there's no penalty, no look back for that. That's an exempt transfer, which happens quite often. There again, you need a power of attorney to do that, a power of attorney document. So living trusts, people are using them primarily to preserve their house, but you can preserve your other assets in there too. They're also known as irrevocable trusts. They can be revocable or irrevocable. Now, to be Medicaid, protect your assets from Medicaid eligibility, it has to be an irrevocable trust. And you can't be the trustee. So normally people will appoint one or more of their children to be the trustees or co-trustees, and there's a trade-off. You can't have everything. It's like you transfer it to a living trust, you give up control, you give property away or money away, you're giving up control of it. The same way with a living trust. You will give up control of your assets if you set up an irrevocable trust. Some people are not concerned about asset protection as far as Medicaid, so they may use a revocable trust. But for Medicaid purposes, an irrevocable trust, and there again, you don't have to worry about your children's creditors if it's an irrevocable trust. You do a deed from you to your children as trustees. The house is in the trust. They could sell the house for you and buy you another house if you decide you want to move. Normally, you would only have access to any income or dividends from investments, and the trust would say you don't have a right to any other withdrawals of principal. The only thing that could be withdrawn would have to be payable to your children or grandchildren, which would have to funnel it to you or buy something for you. But you have to give up control of basically the principal of whatever in the trust. So we set them up. Usually we're setting these up for people that want to preserve their house, but you can also, it's irrevocable, but you can add assets to it later on. Your bank accounts, you wouldn't put your IRAs in it, but bank accounts, it can own life insurance policies, and investment accounts. So that would be, your trustees can set up an investment account in the name of the trust. And prepaid funeral accounts, whatever you put in with a prepaid funeral account, whether it's cash or a life insurance policy, is not considered as a resource in counting your $15,900. Talk to a funeral director about that. They will set that up for you. Prepaid plan. IRAs, If there are 401ks, if they're in payout status, which now is went from 70 and a half to 72 years, if they're in a payout status, those are not considered your $15,000 in resources. So it's not considered one of your resources as long as it's in a payout status. The distributions will have to go to the nursing home from your IRAs, but you will, no matter if you have $1 million in your IRAs, you would still qualify for Medicaid. There is something available, went into effect a few years ago if you want to talk to your financial advisors about qualified longevity annuity contracts, which sets it up where the distributions are limited so that you're not going to be, you can retain more in the IRA and not have to pay out so much in distributions, which would end up going to the nursing home. Something to talk to your financial advisors about, see if it's appropriate. So your daughter's been caring for you, your personal needs and bill paying and so forth for the past year, and you want to compensate her for that. If you were to give her a check for $30,000, would that be considered a gift? Actually, it would be. So the only thing that's permitted is what's called, it has to be according to a caregiver agreement. It has to be an agreement in advance, spell out all her duties for personal care and for financial, what the hourly rate is, and reasonable pay in advance. This is really used for a number of reasons. First of all, the Department of Social Services says, I've heard them say it a couple times in public, they hate these agreements, okay? So unless they're carefully drafted, they will reject that and it'll be considered a gift. The other consideration too is that your caregiver child would have to report that income, would have to report that money as income. And technically should be withholding, doing tax withholding and so forth. You can make unlimited transfers to disabled children. There's no limit on the amount. There's no penalty or fee or penalty for that. You can spend down your assets. You are entitled to have one automobile of any value and still qualify for Medicaid. You can pay off your debts, make home improvements. So emergency Medicaid planning with promissory notes is what I discussed before, is why you need a power of attorney with a gift rider. So basically, these are for people that have never done any planning in advance, and this is done when should be done as soon as they enter a nursing home, but this is done when they're in a nursing home, and it involves 2 Medicaid applications. So essentially, you can give away your assets to your children, and then they're going to promise to repay half of it to you. It's a very precise calculation, depending on all your debts and nursing home costs and medical bills and so forth and what your assets are. It's a very complex calculation, and they're going to repay you half of it, and they'll be able to keep the other half. And so when that money runs out, that half of your assets run off, you will qualify for Medicaid. So it actually involves 2 Medicaid applications prepared by an attorney. First, when you first make the gift, you do want to get turned down for Medicaid with your first application, believe it or not. And then you will qualify for Medicaid on your second Medicaid application. So if it all sounds confusing, actually most attorneys are not even aware of this. We've done this both with powers of attorney, and we've done, like I've said before, we've done these through guardianships. Judges will order this gifting with promissory notes in Supreme Court through guardianship proceedings if a power of attorney was never executed. So guardianships can be done for taking care of someone's all their needs, or it can be, very often it can be done for limited purposes like doing this gifting with promissory notes to fulfill the person's, they will look at the person's will to see what their intention was, if someone can't express that, but if you show the court that was the person's intention, even though they can't express that they wanted all their kids to share in their estate eventually, that the court can order that a gift be made of half of the person's assets while they're in a nursing home using this emergency Medicaid with a promissory note. Finally, has both financial and other consequences. How many people here have healthcare proxies? So there's a healthcare proxy that came about by New York legislation. There's also living wills, not living trusts, but living wills. Sometimes they're separate documents. We do it as one document. The healthcare proxy, you appoint one agent and an alternate agent to make healthcare decisions if you become incapacitated, including your healthcare agent can authorize a DNR. Okay, a DNR is not signed by you. A do not resuscitate order is signed by a doctor regarding whether or not you want your breathing or your heart resuscitated for a particular procedure. So healthcare proxies, living wills are only valid in nursing homes and hospital settings. Your healthcare proxy and your living will on your refrigerator will not be honored by the paramedics. For that, you need to have another advance directive called a medical order for life-sustaining treatment. That's completed by your doctor. So if you have a relative that's in hospice and you're their agent, you may want to ask their doctor to complete this medical order for life-sustaining treatment that you do not want to be revived. If the EMTs come to your house, especially when someone's under hospice care, because they cannot honor healthcare proxies and living wills. So, living wills came about as a result of a Court of Appeals decision, in which you can designate what treatment you do or do not want. If you do not want to be kept alive, for instance, we specify in our living wills if you're in a coma, non-terminal illness, terminal illness, and also non-terminal illness, like the later stages of Alzheimer's when you lose your functionality and be able to function. And also, your healthcare agent cannot order discontinuance of tube feeding or artificial hydration unless you specify that in your living will. So in our living wills, you can specify, I do not, under the circumstances when they discontinue everything else, I don't want to be kept alive by tube feeding or hydration. So, the famous case of Terry Schiavo in Florida, she lingered for 11 years when her ex-husband and parents fought over her, keeping her alive. I'm sure she didn't want to be remembered the way she was, all having tubes out of her, in her final days on TV. So that's why it's important you specify that if you don't want to be kept alive like that, and appoint your agents. There's also HIPAA authorizations in the healthcare proxies and the powers of attorney, so your agents can discuss your billing with your hospitals and your doctors. So it's important to do. In 2010, there was the actually 11 years ago, there was a Family Health Decisions Care Act, which authorized family members or unmarried couples to make medical decisions for one another. And so that's all the more, and also children, it's all the more reason why you should have a healthcare proxy and living will, because if you don't have one under the Healthcare Decisions Act, New York State Healthcare Decisions Act, people may be making decisions for you who have no idea what your wishes are. So it could be a child that has no idea what your wishes are, or someone else. So it's all the more reason that it is available. It has those people would have limited authority, but still they can make healthcare decisions for you.